The women's ones are more or less here at the bottom of the stairwell, and diagonally across the quadrangle are the men's, and there is one gender-neutral facility on level 4. In the quadrangle, in the foyer outside these lecture theatres, you will see displays of books for your interest. I ask you please to attend the sessions on time and to vacate the venue and then take your stuff with you at the end of the session. Each of the venues is on this level. This is Lecture Theatre 1, the biggest. Lecture Theatre 2 is just this side, and Lecture Theatre 3 that side. So you're all on one level. You don't have to move very far. Tomorrow is going to be a long day. We start at 9, and we proceed straight at 5 o'clock by bus or other conveyance to the gala dinner. So if you wish to wear glad rags, wear them from 9 o'clock onwards. So there are going to be no changing facilities. Please also look after your valuables. You each have been given what I think is called a tote bag, which has got some wonderful things in it, particularly something to keep your head warm, and a commemorative copy of South Africa's Constitution produced by one of our sponsors, Judicial. Fridays are 6:30, Saturday ends at 3 p.m. and those who are anxious about making their flights, it's about 12 minutes to the airport from here in a stable state Saturday afternoon. Please do not smoke any substances anywhere on this campus. If you have any questions about the conference, all the members of the committee have a yellow stripe at the bottom of their cards, and we have 6 student assistants as well. Oscar, will you just stand? Oscar's one of them, and they also will be able to help you with any questions that you have. It's terribly important, given who we have in the audience, that you please wear your lanyard at every moment. You will not be given access to the building tomorrow unless you're wearing your lanyard, and you will not be given access to lecture theatres unless you're wearing your lanyard. So please take that seriously. Finally, it's important, none of this would have happened had we not got magnificent financial support. Most of the donors are mentioned at the bottom of the program, but I just want to bring credit to them now. The Millennium Foundation, the Deans of Law at Cape Town, University of the Western Cape, UCT, University of the Western Cape, and Stellenbosch, attorneys firms Bowmans, Cliff Decker Hofmeyer, who have sponsored the gala dinner tomorrow evening, Edward Nathan Sonnenberg, ENS, you can see them all over in the tote bags and the lanyards and other places, and Weber Wenzel. From the legal publishing side, Juta and LexisNexis, and LexisNexis is our nominal sponsor of the cocktail reception, which will follow immediately after that. Thank you. I've taken enough of your time. I'm going to hand over to Justice of the Constitutional Court, Stephen Majiedt, who's also the progenitor of this conference happening in Cape Town. I'll hand over to him. Thank you.
Good evening, everybody. Good evening, everybody. I'd like to acknowledge the Deputy Chief Justice, Justice Mlambo, retired Justice Albie Sachs. In Albie's case, retired is an utter misnomer because he's busier now in retirement than when he was in active service. The Vice-Chancellor and the Principal of this terrific institution, Professor Mosa Moshabela, the Dean of the Faculty of Law, Professor Mohamed Paleker, the Judge President and the colleagues from this division and also colleagues from other divisions, and ladies and gentlemen from all over the globe, you'll be welcomed properly, but let me say that we are absolutely delighted to have so many of you here, as you have said, without sound, but I'm going to continue, at PLC 26, at the southern tip of the mother continent, the birth of humanity, birthplace of humanity. Just very quickly about
this will just take a moment. Are you still getting sound? Are you getting sound? Apologies, sisters. We'll just take a moment. Just switch it off the other plug quickly. Back on. Give us back. Give us back. Okay. Yeah. Just give me a moment.
Thank you. Let's hope that's the last of it. I wanted to say something in brief about how the conference came to be held in Cape Town, the first time on the African continent. And so I was privileged to attend PLC 22 in Dublin, and that's when the Irish Constitution turned 100. It had its centennial, and I mentioned to Cora Hooster as one of our co-organizers and was also at PLC 22, how impressed I was with this conference. And in Canada, in Ottawa in 2024, I had the audacity to suggest that we should bring it to South Africa, also because we are celebrating our 30th anniversary of the final constitution. And that was one of my less lucid moments, because Jason Verhoeven, who's the director of PLC, in front here, he agreed, and we made the announcement in Ottawa. And when I got back to South Africa, the reality set in. And I thought, how am I going to do this? And I called on that old, not in an age way, but proven, indefatigable and irrepressible warrior, Hugh Corder, to help me. And we were together in the trenches in the 80s here in Cape Town when we fought apartheid, and I knew that I could count on me, and he came to my aid, and we brought Cora on the Hoekster on board, and then a magnificent team of UCT local organizing committee. I'd like them to stand, please, quickly in this order that I'm going to say now. You've met Hugh, but I'm going to ask to do, I'm doing it alphabetically. Joanna Bakilana. Lisa Draga, who's from my old university, University of the Western Cape. Cora Hoekster, who's from Wits, up in the north. And then from UCT, both of them, Salona Lachman and Dan Mafora. And also from UCT, Nikki Palmer. Bradley Slade from the University of Stellenbosch. Sanya Samtani, who's from the University of Cape Town. And last but not least, our boss all the way from Melbourne, Jason Verhoes. Oh, I forgot Catherine Willis-Smith. Also from UCT. We've been very well supported by Gabby Ritchie and by the Dean, Professor Mohamed Paleker, and others. Thank you. There'll be a vote of thanks later, but let me express my personal gratitude for the wonderful work that you've done to have us here today. Now, this conference, as many of you would know, because I see some familiar faces here from previous conferences, but for those who haven't been here yet, this is a biennial series of major international conferences in public law, in common law systems. And it's become the leading regular international forum for a scholarly discussion of public law and common law systems. And it was founded in Cambridge in 2014, and so for the first two conferences were held at the University of Cambridge, 2014 and 2016. Subsequent conferences, University of Melbourne in 2018. We skipped 2020 because of the dreaded COVID-19 pandemic. Then Dublin, as I've said, in 2022, Ottawa in 2024. And here we are, we've made history. It's the first time on the African continent. And we're very pleased to have it here. And the idea of moving it around the different host universities and countries is to bring it to different audiences and to bring different perspectives into the conversation and to focus attention on public law issues in different parts of the common world. It's also aimed at, as I've said, marking milestones or anniversaries like Dublin 2022, the 100th year anniversary of the Irish Constitution, and this year, our 30th anniversary. And we bring together scholars and practitioners and judges and officials as a transnational community of common law public lawyers. We focus on the development of early career scholars. As you know, we have the doctoral panels. We have the Richard Hart Prize for the best paper by an early career researcher. We have fee waivers, special fee waivers for doctoral speakers. And we include early career scholars in the organization of the conference. And through this conference, the common law provides for us the commonality that underpins the series. But we also understand the importance of drawing comparisons and to understand how to be responsive to different contextual and legal features of different jurisdictions. And so let me just say that as we begin these exciting 4 days, I really look forward to the stimulating engagements which become the hallmark of these public law conferences. Of course, the world looks very different at PLC 26 than it looked at PLC 24. There seems to be a global pushback based on populism and unilateralism against constitutionalism, and we feel it in many parts of the world, all over the world. I wish you a wonderful time here at PLC 26. And if there's anything that we can do to make your conference and your stay in South Africa's mother city more pleasant, please do not hesitate to reach out to us. And the people who are standing at the student assistants, you will recognize him. I'm in contempt of conference, not of court, because I forgot my lanyard. We are here to help, including me, so please reach out to us. And with that, I'd like to introduce Professor Mohamed Paleker, who's the Dean of the Faculty of Law. He's going to give a brief welcome. Mohamed is an attorney by profession, and I met him many years ago when we were both on the rules board for courts of law of this country, and I chaired it at some stage. And he always struck me with his sharp knowledge of the rules of court, especially in the magistrate's court, and formidable practical insights about what the application of rules mean in practice. So Professor Mohamed Paleker, the Dean of the Faculty of Law, who was appointed, if I'm not mistaken, earlier this year. Prof.
Thank you, Justice Majiedt. In the interest of time, I'm going to keep the introduction short, so I'm just going to say good evening, distinguished colleagues and honored guests. As Dean, it is my great pleasure to welcome you to the Wilfred and Jules Kramer Law School. We are delighted to host this gathering of public law scholars and practitioners from across the world. I trust that your time in Cape Town and within the Faculty of Law will be both enjoyable and intellectually rewarding. As this is our mid-year vacation, you will experience a much quieter building, but in the coming days, I think it will be once again enlivened by the exchange of ideas and debates that lies at the heart of academic life. This conference, as you've heard, has been more than 4 years in the making, and I would like to extend my sincere gratitude to all the local and international organizers whose commitment and hard work has made it possible. But I'd also like to thank my colleagues at the University of Stellenbosch and UWC for their sterling efforts in bringing this conference to fruition. It is particularly fitting that we gather here at this moment as South Africa marks the 30th year of the anniversary of its constitution. For me, that anniversary carries a particular significance because 30 years ago, I began my professional working life as a researcher to the Constitutional Assembly during the final stages of the constitutional making process in 1995 and 1996. For most of my academic career, I rarely spoke about that experience. Perhaps I was reluctant to draw attention to it, but I also realized that it was a unique and extraordinary experience that would never be repeated ever again. Because you have only to think about the people that were involved in that particular process, and I think you can imagine who they are, and it would be impossible to replicate something like that again. But it remains one of my defining experiences in life, because it is difficult to explain what it was like to witness a nation attempting to reimagine itself and to contribute in my small way to the creation of a new constitutional order. As the 30th anniversary has approached, I found myself reflecting more on those years. Perhaps age brings with it a greater appreciation of the significance of certain moments in one's lives. I think that as you get older, you also become more nostalgic about the past. But the constitution that emerged from that process was never intended to be merely a legal document. It was conceived as an aspirational project, a commitment to building a society founded on dignity, equality, and freedom. It sought not only to overcome the injustice of apartheid, but also the deeper legacies of exclusion and inequality that had shaped South Africa for centuries. And 30 years later, our constitutional story has been a complex one. There's much of which we can be proud of. Our constitutional democracy has endured, fundamental rights have been protected, and the rule of law has remained a central feature of our public life. But there's also been some profound disappointments. Many of you would have traveled from Cape Town International Airport into the city. And along the journey, you would have seen striking contrasts between wealth and poverty, Those contrasts remain amongst the most visible reminders of the unfinished work of transformation in South Africa. But I do not believe that this represents a failure of constitutionalism itself. The Constitution established a framework of democratic governance and entrusted the legislature, the executive, and the judiciary with distinct responsibilities. Where progress has fallen short, it is often because institutions and individuals have failed to live up to those responsibilities. The familiar temptations of greed and pride and self-interest have far too often displaced the values of service, accountability, and integrity. Yet these challenges is not unique to South Africa, because across the world, constitutional democracies are confronting the same questions about governance, legitimacy, rights, and social justice. It is precisely for that reason that gatherings of this nature is so important. Over the coming days, I hope that your deliberations will be insightful, that they will be challenging and productive. I hope that they will deepen our understanding of the role of public law in addressing the pressing issues of our time. But most importantly, I hope that they will remind us that constitutional law, and indeed public law, is ultimately about people. It's about their dignity, about their aspirations, and the kind of society that we wish to build together. May this conference be intellectually enriching, professionally rewarding, and personally memorable to you. I hope that you leave Cape Town with valuable insights, new friendships, and fond memories of your time here. Thank you very much.
Thank you, Professor. Next, I want to introduce Professor Mosa Moshabela, our chief host here. He's the Vice-Chancellor and Principal of this august institution, and he was appointed in 2024 as Vice-Chancellor. He's a medical doctor by profession, but he has a long, illustrious career in both academia, and he's a formidable medical researcher, especially in public health. So Professor Moshabela, please come to the podium.
That introduction sounds like I'm very old. Chief Justice Mandisa Maya in absentia, Deputy Chief Justice Dunstan Mlambo, Chief Justice Mumba Malila of Zambia. I'm glad that you were able to enter the country. Chief Justice Perez of Samoa, Justice Albie Sachs, the Dean of our law faculty. I want to also just acknowledge the organizers, Hugh Corder, and the co-chair, Jason, as well. I want to acknowledge all the members of the organizing committee. I want to recognize all of the leading judges, practitioners, academics, scholars, and the entire legal fraternity present here. All the other members of the faculty and leadership here at the University of Cape Town, and also from our neighboring institutions. Let me greet all the students that are present in the room, our future scholars and leaders, future justices and judges. Good evening to all of you. Welcome to the University of Cape Town. And let me also welcome you, join those colleagues that are welcoming you to the 2026 Public Law Conference. Hugh mentioned that this conference has been several years in the making. I should also tell you that he contacted me about a year ago, asking me to put this in my calendar. He did not quite have a date at that time. He said somewhere around beginning of July. But make sure that you can come and open it for us, because it is the first time that it's coming to the African continent. Can we give this a round of applause? I'm so happy that I've been able to join and to be here and to welcome all of you and to congratulate you for pulling together this conference on the continent for the first time. Even that 5 minutes of downpour did not stop me from coming to join you. I also think that it is so special for us as the University of Cape Town to be able to host. I think we take for granted the importance of being able to convene and bring people together. And right now, I just want to give shout out to everyone who's been involved in making sure that the conference will come to South Africa, will come to the continent. Shout out to everyone who's made sure that we were able to convene here at the University of Cape Town. I think it also symbolizes the significance of the role that universities can continue to play in creating a space for dialogue, for engagement, for debate. In a world where it's become difficult to have differing views, it's important for us as universities to create a space that says it's okay. Let's engage. Let's put our views forward. Especially when you've got people coming from different parts of the world with different experiences. And these experiences need to be shared for us to be able to learn from one another. So thank you very much for gathering here, and feel free to explore the University of Cape Town, make it your home for the few days that you will be here with us until Saturday. Those of you who are also in Cape Town for the first time, please enjoy the city and take some time to explore it. Jason, I'll be very crossed if you don't take a hike up Table Mountain. You're welcome to Cape Town for the first time, and please, I'm sure that a lot of people here will be very happy to show you around, and apparently even Hugh, after all these years, is still finding new spots in Cape Town. So please enjoy it. I also wanted to just extend greetings to our Chief Justice, Justice Mandisa in absentia. I understand that she really wanted to be here, but because of health and other reasons, she is not able to join us, and we wish her well. But I'm grateful that she recognizes the importance of this meeting and has made effort to stay connected with us, but also the fact that the Deputy Chief Justice is here. And although it's been a while that she has taken the role, please let her know, Deputy Chief Justice, that we extend our belated congratulations on her appointment, just so that she also knows that her appointment means a lot to all of us. I think that being the first female Chief Justice of the Republic of South Africa is not something to take for granted. And I think that many young ladies, young girls are also looking to her with admiration as an inspiration for them as well. from across the country, and I know that the job is tough, but even in all those challenges and difficulties, may she remain strong and remain the inspiration that she is to so many. I also just want to acknowledge the moment that we are in. I think some of us, especially those of us who are coming from other fields, come from the health sciences, from medicine, increasingly when we look at what is happening in society, in the country, we begin to have much greater appreciation of law, especially public law, with what we are seeing in the country for so many reasons, so many layers. We're increasingly having appreciation of this field. And I know that I don't need to preach to all of you, but I do want you to know that those people who are not in this room rely a lot on those of you who are in this room. Because we're finding ourselves asking a lot of questions, not just in terms of the challenges and the difficulties that we are seeing in the country, but also globally. We're asking ourselves about the state of the world and the sort of divided world that we're living in, the fragmentation. And we're asking a lot of questions about what the future looks like. And so as you engage, I encourage you to really remember that your conversations also pertain to other aspects that we are looking at, that we are seeing in our society, in this country, on the continent, and in the world. And there are many people who have vested interest in the kind of conversations you are having who are not here, and who their well-being and their futures matter because of the conversations that you are having. I know that it's already been acknowledged the moment that we are in as South Africa, the 30th anniversary of our democratic constitution of 1996. And I think this is also something that we must not take for granted. You know, sometimes when things don't go wrong, you start to take things for granted until things start going wrong. And then you ask yourself, why have we taken things for granted? And so, in your conversations, please consider the fact that the Constitution matters to South Africans. And for so many reasons, we may, as South Africans, sometimes take things for granted until we've got problems. But if we allow for the democratic values that we enjoy to erode, if we allow for the democratic institutions that we have to erode, the democratic structures that we have to erode, we are going to find ourselves looking back, wondering what happened, and the generations that are coming after us will be very disappointed in us in terms of what is it that we did when we had the opportunity to do something about it. So I hope that you can reflect on this, because it is my hope that our democratic institutions can only grow stronger and not weaken. Our democratic values can grow stronger and not weaken, so that those who are coming after us can also continue to benefit from the same thing that we are benefiting from, maybe even better. I I know that we are also at a point where, in as much as we want to protect our constitution, we want to protect our institutions and our values, we also have to be critical. We have to ask the difficult questions. We have to reflect. And I know this is not only for South Africa, but I can only hope that the space that you've created here will also allow you to ask those difficult questions, to question, and to create space for people with differing views to also share those differences and engage with them. Some of the key questions that I think we have to think about is that there is this connection of the changes that are social, changes that are economic, changes that are technological, and also because of climate change, changes that are environmental, that are all going to affect what we do. And even for us as universities, we are beginning to ask ourselves who we are, what our identity is going to look like in this sort of new world that we are looking at for the 21st century. Everybody, we are all asking ourselves questions. And I know, we just talk about AI, but it's more than that. We talk a little bit about things that have to do with climate change, but it's more than that. When all of these things start to intersect, it challenges even what we think we know. So I hope that you will all take the time to reflect also on the kind of intersection of the changes that we are seeing in the world. Let me thank the University of Cape Town for creating space for you, the Faculty of Law for creating space. And I want you to know that it is an honor for us as the University of Cape Town to host you, and I'm hoping that your discussions are going to be fruitful. You can please forgive the little disruption that happened. We are only learning from the World Cup in the US that now even soccer has to take hydration breaks. So we are also taking technological breaks. But in all of that, please, let's engage in a robust manner, let's engage in a respectful manner, and let's ensure that the future of constitutional democracy is going to be supported by the effort of individuals like yourselves, communities like yourselves, that are going to defend and advance the principles upon which democratic societies are built, and not only the legal text and institutions. I really wish you well in terms of your discussions. Let it be stimulating and productive. Let it be an inspiring conference. Best wishes to all of you.
Thank you, Professor. We, as an organizing committee, felt the warmth of this institution as we arranged this conference, and we'd like to thank you for enabling us to do this, Professor. It's not mere words. We felt the welcome throughout the time we arranged this conference. And Professor Moshabela has made an important point that we must not take things for granted. Just before this session, we had a session in the auditorium next door with the NGO and civil society sector, and they reflected on 30 years of jurisprudence and how you measure your successes, especially in the enforcement of socioeconomic rights. How do you operate in a space where constitutionalism appears to be shrinking, where funding appears to be shrinking? And I said there that where you go around the world, it's my experience that this court, the court's jurisprudence, but also the Constitution, is widely praised. And I said, that's got nothing to do with judges or justices, because we hear the cases that come to us. It's got everything to do with what the role that they have played as NGOs and as civil society organizations. And I think we must continue to be that robust about the enforcement of rights. Now, Koda has alluded to the curveballs that are thrown to us. One of them is the unfortunate fact that the Chief Justice can't be with us, and I'm permitted to share this with you, that she has had a major medical procedure and that her recovery took longer than we thought it would. And so we had to move around the program and make do with an audio recording. And it'll be for about 20 minutes, and she will speak about judicial leadership in a democracy. And she sends her sincere apologies for her absence, and the entire transcript of her full speech will be loaded on the Google Drive after this. And then the Deputy Chief Justice Mlambo will give some additional perspectives just after this. Now, Chief Justice Mandisa Maya holds a number of historic firsts in the judiciary in South Africa. She was the first woman appointed as the Deputy President of our Supreme Court of Appeal, which, despite its name, is not the Supreme Court, but the second highest court in the country. And then she became President of the Supreme Court of Appeal. She was the first Deputy Woman Chief Justice, and on 1 September 2024, she became the first female Chief Justice that this country has ever had. And she is a remarkable person, and she's a role model for aspiring young females, but for all of us, especially those who come from the poor rural areas. And so let us listen to this message on the topic, Judicial Leadership in a Constitutional Democracy. Thank you.
Program Director, Vice-Chancellor of the University of Cape Town, Professor Mosa Moshabela. Dean of the Faculty of Law, University of Cape Town, Professor Mohamed Paleker. Retired Justice of the Constitutional Court, Justice Albie Sachs. Members of the South African Judiciary and colleagues from other jurisdictions. Members of the legal fraternity and academia. Representatives of civil organizations, students, members of the media, distinguished guests, good evening. Please allow me to start by expressing my deep appreciation for the organizers of this conference and my colleague at the Constitutional Court, Justice Majiedt, who has been involved in the conference arrangements. It is a profound honor to share my thoughts, my vision for, and my anxieties about a subject that sits at the very center of our constitutional project, judicial leadership in a constitutional democracy, especially in these challenging times. It is generally expected that there will be moments in the life of a nation when it becomes necessary to pause, take stock, ask and answer honestly whether the country is still walking in the direction of its founding values and ideals, and if its institutions, including those entrusted with the administration of justice, are performing their function with the fidelity, the courage, and the transformative force demanded by its constitution. I believe that we have gathered at such a moment. 30 years into South Africa's constitutional journey, the nation finds itself in a highly charged atmosphere when it feels that the rule of law is at its most fragile and everything might erupt into chaos, from endemic corruption in and the gross mismanagement of vital state institutions and the country's resources. Critically, public trust in the judiciary is at low ebb and continues to decline, not just in South Africa and the African continent, but globally. The conversation about the role of a judiciary and its leadership, governed by a transformative constitution, has never been more urgent. Today, we speak about judicial leadership in a constitutional democracy, not merely as an academic exercise, but as a matter of practical national consequence. The vision we carry for the judicial system of this country, the standards to which we hold ourselves, and the choices we make to realize it will determine whether the constitutional project succeeds or falters in our generation. South Africa has undergone a remarkable transformation since the dawn of her constitutional democracy in 1994, from a legal order that was deliberately constructed to entrench oppression and deny the humanity of the majority, a legal order in which the courts were too often instruments of injustice rather than guardians against it. South Africans inherited the extraordinary task of building something entirely different, a constitutional state in which the rule of law would prevail. The founders of the country's constitutional order were not naive about the immense difficulty of that task, but they were bold in the vision they inscribed in the text. It is that vision and our fidelity to it that I wish to discuss today. South Africa is a constitutional democracy founded on the recognition that democracy, the rule of law, and the respect for human rights and fundamental freedoms are interdependent and mutually reinforcing, and the exercise of all public power, legislative, executive, and judicial, is constrained and directed by a supreme constitution. Section 1 of the Constitution of the Republic of South Africa, 1996, declares that South Africa is founded on, amongst other values, human dignity, the achievement of equality and the advancement of human rights, non-racialism and non-sexism, the supremacy of the Constitution, and the rule of law. These are not mere aspirational sentiments, but are actionable mandates that animate every aspect of the judicial function. And the judiciary is the institution that gives meaning to the constitutional text and serves as the ultimate guardian of the rule of law. That is what places it at the core of the constitutional democracy. The Constitutional Court has made clear that judicial independence is foundational to and indispensable for the rule of law as guaranteed under Section 1C of the Constitution and is not subject to any limitation. These are not soft principles, they are hard constitutional architecture. The authority to govern through the interpretation of the supreme law is authority that must be exercised with wisdom, restraint, intellectual rigor, and an abiding consciousness of the constitutional purposes it is designed to serve. This is where judicial leadership begins, in the intellectual and moral quality of adjudication. Judicial leadership is not simply the ability to deliver quality judgments, although intellectual rigor is its indispensable foundation. It is not merely the capacity to manage the operations of institutions and administer courts, although effective administration is essential to the delivery of justice. Judicial leadership, properly understood, is the integration of the constitutional vision, institutional stewardship, moral courage, and commitment to the exercise of judicial authority. I deal with each of these elements. First is intellectual leadership. Courts shape the law. Every judgment is an act of institutional leadership. It tells the state and the citizenry what the Constitution means and demands and sets precedent. Judicial leaders must bring to this function constitutional interpretation that is consistent with the transformative objective of the founding document, a willingness to grapple honestly with hard questions rather than retreat to formalism when the resolution of the legal dispute requires courage, especially in the toxic climate that has taken root, where courts are applauded when they decide against political opponents and are viciously attacked when they decide against allies and dismiss popular narratives. The second element is institutional leadership. A judicial leader does not only adjudicate cases that come before the court, she sets the tone for the court's culture, its values, its work ethic, its treatment of court personnel, and its relationship with the communities it serves. She is responsible for identifying the operational needs of the court, ensuring that the court functions efficiently, backlogs are managed and eliminated, resources are deployed intelligently in the dispensation of justice, and quality is maintained. This is painstaking and glamorous work, but it is the work upon which the credibility of the institution is built. The third element is ethical leadership. Judicial officers are, by the nature of their office, expected to embody the values they interpret from the bench, A judge who fails to live by them does not merely expose herself to disciplinary proceedings, she brings disrepute, potentially irreparable, to the judicial institution. The fourth element is transformative leadership. The South African judiciary does not exist in a historical vacuum. It exists in a society still profoundly marked by the inequality and exclusion of the past. Judicial leaders must understand this context and give it its proper constitutional weight. Transformative constitutionalism, the concept developed in our scholarly and jurisprudential tradition, that the Constitution is an instrument that serves not merely to stabilize the existing order, but to entrench equality and dignity, demands of judicial leaders a constant, conscious orientation towards the substantive justice that the Constitution promises. But transformative constitutionalism also demands something of judicial leaders in the way they run the judicial system. A judiciary that speaks eloquently about equality from the bench, but practices inequality within its own ranks, contradicts and undermines its own moral authority. This discussion would be incomplete without reference to judicial independence, a concept that is fundamental but often misunderstood. Judicial independence comprises two aspects. The first is institutional independence, the structural and actual independence of the judicial branch from outside influence from the executive, the legislature, political parties, and powerful private interests. The second is adjudicative independence, the independence of the individual judge to decide each case on its merits according to the law and the evidence without pressure from any quarter. Both characteristics are essential. Without institutional independence, the judiciary cannot function as a co-equal arm of the state capable of holding the other arms to account. Without adjudicative independence, individual judges cannot discharge their constitutional oath to administer justice without fear, favor, or prejudice. However, judicial independence does not mean that judges are above accountability. Judicial independence is not a personal privilege of judges. It is a constitutional guarantee provided for the benefit of those who appear before the courts and for society at large. It protects judges not so that they can act freely for their own purposes, but so that they can serve the constitutional purposes of their office free from improper pressure. The tension between judicial independence and accountability is one of the defining challenges of judicial governance in any constitutional democracy. In South Africa, this tension has been highlighted by a period in which questions about the conduct of some members of the judiciary and allegations of corruption and capture within the institution have tested the credibility of the institution. When a majority of citizens lack confidence in the courts, the constitutional promise of justice cannot be fully redeemed. Public trust is the source of judicial legitimacy. Without legitimacy, judicial authority is ultimately hollow. The imperative is clear. Judicial leaders must model, champion, and enforce the highest standards of ethical conduct within the institution. Section 174, subsection 2 of the Constitution contains a provision that is easy to overlook with the passage of time since democracy, but still carries enormous significance for the identity and legitimacy of the judiciary. The need for the judiciary to reflect broadly the racial and gender composition of South Africa. The legitimacy of the courts derives in part from the extent to which they reflect the society they serve. A judiciary composed entirely of men cannot fully represent the full range of human experience, including, critically, the experiences of women who bring before the courts matters involving gender-based violence, discrimination, reproductive rights, and family law. A judiciary that is racially unrepresentative of the population it serves struggles to claim the moral authority to adjudicate matters arising from the legacy of apartheid and matters affecting that segment of society generally. The racial and gender transformation of the judiciary is not a concession to political correctness. It is a constitutional and institutional imperative. Needless to say, the need for racial and gender transformation necessarily extends to the leadership of the judicial institution. For all these reasons, I have alluded to the challenges confronting the judiciaries in South Africa and beyond. We must deal squarely with the reality that we live in a moment of global democratic fragility. Across the world, constitutional democracies are under stress. The institutions of liberal democracy, free courts, independent media, democratic elections, separation of powers, are all being challenged in ways that would have seemed implausible a generation ago. In many jurisdictions, it is the courts that have been the last line of defense against the slide towards authoritarianism. And in some cases, the courts themselves have been compromised or captured by the forces that they were meant to keep in check. South Africa is not immune to these global currents. Her own democratic landscape has been shaped and reshaped by the corrosive effects of state capture, by the weakening of legislative oversight, by the abuse of executive power, and by the persistent failure to deliver on the constitutional promises of equality and dignity for all. Democratic resilience, the capacity for constitutional democracy to withstand and recover from institutional stress, depends in significant measure on the quality of judicial leadership. As I have said, judicial leaders are not merely institutional managers. They are, in the deepest sense, guardians of the constitutional order, the last and most important line of defense against the disintegration of the rule of law and the descent into governance by power alone. I should say something about the spirit in which judicial leadership must be exercised, because the spirit matters as much as the substance. Leadership at its most elevated is an act of service. The judicial officer who understands this will approach her work with a quality of attention and care that cannot be compelled by any code or regulation. She will remember that every case before her, however routine, technical, and administratively inconvenient, involves a human being whose circumstances have brought them to the threshold of the court, seeking something from a system that often bewilders and intimidates them. She will bring to each matter not only the full force of her intellect, but the full weight of her humanity. In our constitutional tradition, the concept of Ubuntu, that profound African philosophical insight, captured in the expression umuntu ngumuntu ngabantu, meaning a person is a person through other persons. Jurists who have left the deepest mark on our constitutional order, for example, Chief Justices Arthur Chaskalson, Ismail Mohamed, and Pius Langa, Deputy Chief Justice Dikgang Moseneke, Justice Albie Sachs, Justice Kate O'Regan, Justice Yvonne Mokgoro, and others shared this quality. Brilliant legal minds, but also people of deep moral conviction, understood that the bench is not a platform for personal distinction, but is a responsibility of public service. They brought to their judicial work a sense that what they were doing mattered, that each judgment was a contribution to the ongoing construction of a society worthy of the sacrifices of those who had fought to bring it into being. That is the spirit in which judicial leadership must be exercised today. As I draw this address to a close, I wish to set before you a vision of the judiciary that the Constitution demands, that society deserves, and that we as judicial leaders are obliged to foster. A judiciary that is truly independent, a judiciary that is accountable, a judiciary that reflects the nation itself, whose composition in terms of race, gender, and social background reflects the diversity of South Africa. A judiciary that is accessible not only to those who can afford expensive legal representation, but also to the poor, the rural, the unrepresented, the marginalized, to every person who has a right that the law recognizes and who is entitled to have that right vindicated in a court of law. A judiciary that is sensitive to the developments in society, in the society itself, and is efficient. And above all, a judiciary that is courageous enough to hold the powerful to account, whatever the consequences, courageous enough to give full effect to the constitutional rights of the most marginalized, whatever the resource implications, and courageous enough to acknowledge its own weaknesses and flaws and to pursue reform with urgency, transparency, and genuine commitment. The Constitution of the Republic of South Africa is, by any measure, one of the most remarkable constitutional documents in human history. It is the product of an extraordinary negotiated transition from a system of institutionalized racial oppression to a constitutional democracy founded on human dignity, equality, and freedom. It promises its people dignity, equality, justice, and the protection of the law. And it places on the judiciary the responsibility of being the ultimate guardian of those promises. But a constitution, however well-meaning, is only as strong as the institutions that give it effect. And those institutions are only as strong as the leaders who give them impetus. The Constitution does not enforce itself. The rule of law does not maintain itself. Judicial independence does not defend itself. These concepts are sustained only through the daily, deliberate, courageous choices of the women and men entrusted with their administration. That it is in the interest of every citizen in the free world that the rule of law prevails cannot be overstated. And of course, judicial independence is indispensable to breathing life into this founding constitutional value. Each one of us who occupies a position of judicial leadership carries the responsibility to promote access to justice, ensure that courts produce just and timely decisions, and instill a sense of fairness so as to build public confidence that the rule of law serves everyone equally. We have to be worthy of the trust that has been placed upon us, lead with intellectual rigor, moral integrity, and an unwavering commitment to the constitutional vision of a society in which every person, regardless of race, gender, class, or circumstance, can find justice and foster the judiciary that the Constitution demands and our fellow countrymen and women deserve. I thank you.
Thank you for bearing with us and for your patience. And when I arranged this recording with the Chief Justice, I sent her the program, and she saw on the program the the colleagues from abroad who are here on the judiciary. And she asked me to convey her greetings to Chief Justice Malile from Zambia, Chief Justice Perezi from Samoa, and also Lord Justice Singh from the UK Appeal Court. She's sorry that she can't be with you, but she conveys her regards and her greetings. Deputy Chief Justice Mlambo will join us now to make some observations from his perspective. He was appointed with effect from 1 August 2025 as Deputy Chief Justice. And before that, he served as the Judge President of our largest provincial division, the Gauteng Division, from 2012 to 2025. Deputy Chief Justice Mlambo, please.
Thank you very much, Justice Majiedt. Let me also acknowledge the Chief Justices in the room, Chief Justice Malila. I met him for the first time online, and I'm happy we're meeting in person, in the flesh today. The Chief Justice of Samoa. I was joking with him that I'm always anxious when the Springboks play Samoa. But I always look forward to celebrating after the game. And Justice Singh from the UK Court, retired Justice Goldstone, Albie. I'm sorry, I'm not being disrespectful. You said I must call you Albie. Justice Sachs. But our judicial host here, JP Mabindla Pakwana, Gubevu. If you want to be in her good books, that's how you should address her, as Gubevu. I also want to acknowledge our main host today, the Vice-Chancellor and the Dean of Law. But I want to observe all the protocols that have been mentioned here. I especially thank you, Vice-Chancellor, for what you said about what's happening in South Africa currently. Some of us cringe when we watch on TV and see extrajudicial conduct expose fellow human beings to inhumanity. So thank you very much for what you said. I think it's one of those occasions when we have to ask the difficult questions. Why has the rule of law failed in that regard? Because it has failed. I will end it there. That's not the purpose of why I'm here. But I couldn't miss the opportunity to mention that. And I say so because I'm very involved with refugee and immigration issues. I'm in the Executive Council of the International Association of Refugee and Migration Judges. But I'm the chapter president, the Africa chapter president of that association. Hence, what you said touched me. I'm here to give local perspectives on what the Chief Justice spoke about, Chief Justice Mayo. It's about three things, maybe two: judicial independence. Our Constitution explicitly vests judicial authority in the courts and guarantees our independence in the courts. Section 165 provides that courts are independent and subject only to the Constitution and the law, and forbids any interference by persons or organs of state. It also imposes a duty on the state to assist and protect courts, ensuring their independence, impartiality, dignity, accessibility, and effectiveness. In practice, therefore, South African judges enjoy adjudicative independence. You heard the Chief Justice, she emphasized that. South African judges decide cases impartially without fear, favor, or prejudice. However, full institutional independence has lagged. Court administration remains largely under executive control. Court funding is fragmented across the Office of the Chief Justice, the Department of Justice, and other state departments, such as the Department of Public Works. As such, courts are still dependent on the executive for resources. Judicial reform efforts, therefore, seek to give the judiciary control over its own budget and administration. There's a phrase called court rationalization. The Constitution mandates rationalization of all courts with a view to establishing a judicial system suited to the requirements of the Republic. This reflects the goal of addressing the fractured court map inherited from the apartheid era. Since 1994, South Africa has progressively realigned court jurisdictions. For example, in the 2000s, minor magistrates' courts measures and the creation of the Office of the Chief Justice in 2010. This was a move towards rationalizing the judiciary into what the Constitution envisages. A major push is now underway to finalize rationalization. The executive has, fortunately now, approved a phased plan to recognize the judiciary and what a truly independent judiciary should look like. The reforms envisaged aim to eliminate legacy gaps in access. Previously, some rural areas had no nearby high court seat, and magistrates' court boundaries did not match provincial borders. The ultimate goal is a single judiciary, merging the entire judiciary under one administration. This was long envisaged. A unified, rationalized court system will strengthen independence by removing artificial barriers between the magistracy and superior courts, by centralizing administration in the judiciary itself. Institutional independence and resources. The Office of the Chief Justice was established to give the judiciary its own department. It is tasked with supporting the Chief Justice in leading the courts and enhancing institutional independence. Under the current arrangement, the Chief Justice is the OCJ's executive authority, and the OCJ Secretary General is its accounting officer. Currently, however, the Secretary General reports to the Minister of Justice and Constitutional Development on budgets and how the OCJ spends its budget, as well as other operational issues, while the Chief Justice oversees all judicial aspects, including judicial policy. Doing it otherwise has serious implications for our decisional and institutional independence. Our view, and this is much debated, is that the Chief Justice cannot be directly called to account by the President or the Parliament for what the judiciary does. We recognize that the Treasury still controls resources, but we need to find a way. We can't use the same template that applies to the executive and Parliament to the judiciary. That is the poser, as other arms report through their leaders. Recent reforms will, however, deepen the separation between the judiciary and the executive. The OCJ will be re-established outside the normal public service, with authority to hire its own staff and set its own internal rules. This architecture mirrors how other independent bodies operate. In future, all magistrates' courts and high court judges will answer to the single Office of the Chief Justice structure. Once implemented, the judiciary will control its own budget, human resources, and courts, and its establishments and operations. This is the final step to full institutional independence. Here's the poser, however: accountability and oversight. The Chief Justice spoke about accountability. So, having said all what I've said, it is not lost to us in the judiciary that we and the executive must, however, find each other on the most ideal manner in which the judiciary accounts to the South African public without compromising its independence in all its facets. Other important considerations regarding our accountability are the pace at which the judiciary processes misconduct matters against its own members. And importantly, it is the pace at which the judiciary processes and finalizes its caseloads, as well as the lengthy lead times to hearing dates and handing down of reserved judgments. These are serious matters that lie at the heart of societal confidence in the administration of justice in South Africa. We're not doing that well in those facets, and we need to find a way in which we are held accountable properly about why that is happening. I see Chief Justice Malila is smiling. I mentioned Chief Justice Malila specifically because these problems are not South Africa's problems only. They are found elsewhere. Public confidence and judicial integrity goes a long way. And despite the many challenges facing our democracy, the courts continue to command a level of public confidence that many other institutions have struggled to maintain. However, public faith is fragile in today's climate of corruption, inequality, and institutional distrust. The judiciary must therefore continue to engage with legitimate concerns about the administration of justice, whilst also resisting unfair or uninformed criticism that can spread easily through public discourse and digital platforms. Public confidence in the judiciary is built over many years, but can be undermined by even isolated instances of judicial misconduct. For that reason, the judiciary must remain vigilant in maintaining the highest ethical standards, and allegations of misconduct must be addressed promptly, transparently, and fairly. Delays or uncertainty in accountability processes risk weakening confidence in the institution as a whole. The recent events that we have seen have served as a reminder that no institution is immune from allegations of misconduct, including the judiciary itself. While allegations must always be approached with fairness and respect for due process, they also reinforce the importance of accountability mechanisms that are credible, transparent, and timely. As the adage goes, justice must not only be done, but must be seen to be done within the judiciary itself. When disciplinary processes are prolonged or appear ineffective, public confidence in the institution inevitably weakens and suffers. Beyond individual cases, structural issues also sap confidence. Judicial resources have not kept up with the caseload or population growth. Court delays, increasing caseloads, and limited resources affect the public's experience of the justice system and, in turn, perceptions of its effectiveness. At the same time, maintaining public confidence requires a judiciary that is willing to hold itself to the highest ethical standards. Strengthening internal accountability, ensuring complaints are dealt with fairly and expeditiously, and continuing to foster a culture of integrity are all essential to preserving the legitimacy of the courts. Ultimately, the legitimacy of the judiciary rests in its ability to fulfill its constitutional mandate. An independent judiciary must also be an accountable, effective, and trusted judiciary. Only by securing both adjudicative and institutional independence and demonstrating transparent accountability will the judiciary restore full public trust. As we begin this conference, I hope our discussions over the coming days will go beyond simply identifying the challenges facing constitutional democracy and will allow us to engage seriously with the difficult questions that arise from them. I hope that our conversations will be practical as well as reflective, that we will consider what steps can be taken by all actors within the constitutional project to strengthen the rule of law and public confidence in our institutions. And it shouldn't take 4 years for serious discussions like this to happen. Internally here, domestically, I've always said, we need an engagement between our colleagues in the academia who unpack our rulings and an engagement with the judiciary to say, these are the rulings you've given. This is what the Constitution says. Are you veering away or are you still on track? We need those discussions. Thank you very much.
Thank you very much, Deputy Chief Justice. As I near the end of a career of more than 26 years, I want to just say this about what the Deputy Chief Justice and Chief Justice have said. When you sit in that court, coming from the history that we've experienced as a person, as a young lawyer, you are aware of the immense expectation that the country feels with regard to your role in society. It's an immense responsibility. But when President Mandela in 1995 appointed the first 11 judges, he put together a formidable team, and we were able to build on that jurisprudence, which is admired right across the globe. And we are fortunate to have two of those stalwarts here tonight, Justice Richard Goldstone and Justice Albie Sachs. And I'd like us to give them a round of applause. Justice Albie Sachs was appointed to the Constitutional Court in 1994, October 1994, by President Mandela. And he's written very, very seminal judgments in that court. He's also written very strong dissents. And as we always say to the young law clerks when they come there, we remind them that today's dissent may become tomorrow's law. And so Albie, I think, is in the forefront of very, very strong seminal dissents in that court. Please welcome Justice Albie Sachs to do the vote of thanks.
I felt so proud hearing our Chief Justice. Not bad for somebody who's just undergone surgery. I felt the strength of her mind, of her voice, but especially of her convictions, her heart, her spirit. Earlier this year, I had the delight and pleasure of being invited to a conference in Angola by the first woman Chief Justice of Angola, who had recently, before I went there, been in touch with the first woman Chief Justice of South Africa, Mandisa. And the theme was a theme very underdeveloped on the African continent and generally, the rights of women and girls. It was a Pan-African conference on that, and it was a very powerful conference, very strong. The issues are hard, are sharp, and they were presented in a hard, sharp way. Sometimes law can hide pain through rationality and ideas. This combined thoughtfulness and compassion, and they even had a young girl who chaired the presentations. It was quite brilliant. So Stephen, you would have had somebody aged maybe 11 or 12 sharing the presentation. It was very strong. And I mention that now not simply to recall the role of our Chief Justice on the African continent, but to recall what I said when I was called upon to speak. And it was, thank you to Angola, thank you to Africa. And I said, you sacrificed thousands and thousands and thousands and hundreds of thousands of Angolans for us to get our freedom in South Africa. The racist white supremacy army, what they called the border wars, moved almost right up to Luanda to prevent a government taking over after independence achieved from Portugal that would be in favor of the liberation struggle in South Africa. That invading army provoked civil war, millions of refugees, hundreds and hundreds and hundreds of deaths. We South Africans owe the people of Angola a huge amount. I remembered when I spoke to the Angolans how our young students, after the massacre of Soweto, the uprising in Soweto, thousands crossed our borders to be able to receive training to come back and fight. And Angola provided the main camps where our people were trained to support the liberation struggle. And many joined in defending the independence of Angola. I said thank you to Angola also to receiving a very brilliant and wonderful professor from this very university, Professor Jack Simons. People from the last century like me remember Professor Simons as one of those amazing teachers who have an impact on generations. Not only the content, but the style and the passion. And he was given, after getting a PhD at LSE in London under the great Professor Malinowski, given a course to teach that was called Native Law and You had to learn native understandings to be able to control them and administer them properly. And he turned it around, comparative African government and law. And he taught us a respect for African law, settling disputes as law. He was locked up in the emergency after Sharpeville. When he came back to his class, he said, as I was saying before I was interrupted, the students drummed. It was a great moment. His wife, Ray Alexander, organized the Food and Canning Workers Union. So the theme of the rights of women came very strongly. He was the person who coined the notion of the triple oppression of African women, as Africans, and as workers in the most subaltern jobs. And I mention that because after leaving the country, he went to Zambia first, became a professor there, trained generations of young Zambians, and went to Angola. And he became now the professor teaching the youngsters who were going to come back and fight. And he didn't just teach them ordinary information. He taught them how to think, how to argue, how to debate. A whole generation of leading thinkers, Joel Netshitenzhe, for example, came through that, not learning politics by rote, but learning how important ideas are when it comes to struggle. The South African regime was so angered by him, they paid him the highest honor that they could confer. They sent 2 bombers to drop bombs on the place where the teaching took place. I'm happy to say he accepted that honor in absentia. The word had got through 2 days before he left. The place was bombed to smithereens. I can tell my own story, not dissimilar in relation to my thanks to Mozambique. Mr. Musaji, on the 7th of April, 1988, was walking with his son. It was a public holiday, and a car exploded. It was meant to kill me. It cost me my arm, sight, and one eye. I survived. Mozambican doctors saved my life. They were amazing. Mozambican people provided 7 liters of blood so that I could live. When I hear of people today in South Africa going into hospitals to prevent persons they call foreigners from receiving treatment, I just think of what we got from Africa. I think of Dimpo Hani, the wife of Chris Hani, coming to stay in my apartment in Mozambique, being met by Chris, who very sadly was later assassinated in South Africa. And she's telling him the story of that night in Maseru, Lesotho. And she said, we heard, I'm going to use the language she used, we heard the Boers coming up the stairs, shouting, Hani, we're coming to kill you. And Neo, their daughter, she's telling Chris, 9-year-old, said, Mommy, Daddy said, if the Boers come, we must get down, we must bend down. And she pulled me down, my daughter pulled me down. And then we heard the Boers went to the flat next door. And I couldn't shout and tell them, you're going to the wrong flat, and kill the neighbors. And a Basotho family was destroyed. I think of the 100,000 Mozambicans who from the 1890s every year would come to work on the mines to build up the South African economy, paid a pittance, Portugal was paid in gold. They were paid a pittance. The men who never returned. I think of the extent to which apartheid South Africa tried to destroy Mozambique, provoking civil war, hundreds of thousands of deaths, millions of refugees, child soldiers, destroying the economy. Why? For us to get our liberation in South Africa, a price they paid. And I could go to other countries, other areas. It's not just a question of numbers, it's a question of attitude, of outlook, of contribution. When Tanganyika got independence in the early 1960s, and then joined with Zanzibar to become Tanzania, they wanted an anthem. And the anthem they chose was Nkosi Sikelel' Africa. Our anthem was sung all over Southern Africa where people were dreaming of freedom. I say this with such a sense of, what is it, shame? Shame that the Ubuntu about which the Chief Justice spoke, the sense of human interdependence, of my humanity being enhanced by an acknowledgement of your humanity, it's become part and parcel of our legal thinking. It's entrenched in our Constitution. It underlies the whole of our Bill of Rights project. And to see it being dissipated. I think of the honor that South Africa achieved throughout the continent, it being a bastion of humanity, of forward thinking, of valuing the marginalized, disrespected, not just law to protect those in positions of power and authority from what is seen as the threats from the poor and the marginalized, but to enable the poor and the marginalized to be included. And I see it being dissipated. I feel that it's like a personal hurt. And so many of my generation will feel that. We were hosted in Africa for decades, and Africa paid a huge price for doing so. It wasn't just altruism and generosity yet, it was courage on their part. Many people say to me, Albie, look at the problems of South Africa today. Is this the country you were fighting for? And I pause for a moment, and I say, yes. This is the country we're fighting for. But no, it's not the society we're fighting for. It's not just a lawyer's tricky way of dealing with embarrassment. For me, it's fundamental. We've got a country. We didn't have a country before. We had a constitution that was totally negative, anti-human. Now we have that constitution, not just a product of clever lawyers, but 490 people in parliament. Great majority of whom had been in prison, they'd been on Robben Island, they'd been in exile, they'd been in the underground. It's wonderful that you were there at that birth moment, hearing the first cries of something new that was being born. A strong women's movement that had fought against sexism inside the liberation struggle. It's no accident the term non-sexism in our constitution. Why? It was fought during the liberation struggle. People like Ruth Mompati and Bridget Mabandla and others were saying, we fight racism, but what about male domination? What about patriarchy? Raising that. So all of these themes were strong in the establishment of our new society, the process of establishing it, the people who wrote that constitution, and the people who died in the course of achieving that. It gave us a country, it gave us elections, it gave us a lively, spirited press, it gave us civil society, It gave us strong trade unions. It gave us a powerful women's movement. All of those things incorporated in the quality, sometimes even in the text of the Constitution. And it gave us the Constitutional Court. Richard will remember, and I, how thrilling it was, our first meetings. That sense of excitement, the sense of we creating something. We're not just judges solving problems and disputes. We are a mechanism to do that. We're trying to establish a whole new value system, turning the negative into the positive. We're so different in style, background, personality, but brought together by this particular task. And we knew we were establishing an institution which we had to give its own quality, its timbre, its culture, its resonance. Little things like rotating the seating so that we didn't have seniority with all the rigidity that comes from that. Having artwork in the building to get away from that formalistic, rational ideas abstracted from the world. A whole range of different things. Asking council not to address us, my lord, my lady, simply as Justice so-and-so. And a style of relating to council that I'm happy to say progressive Chief Justices have maintained. I am going to acknowledge my absolute delight when I heard that Mandisa Maya had been appointed Chief Justice, equaled only by my delight when I heard that Dunstan Mlambo had been appointed Deputy. And Dunstan, I heard from people who worked in the Gauteng court when you were there, the difference it made. Just attending to the practical needs, the organizational needs, administrative needs, having weekly discussions and debates, not huge things. What a difference it made. And I felt a particular joy that Mandisa Maya was now. About 20 or so years ago, I'm a fairly young judge, but we're learning quickly. And I'm asked if I'd be willing to help women judges in special education to fast track the advancement of women in the judiciary. It was a time when there was an African Women Lawyers Association was set up, Women Lawyers Association International. That was useful. That was good for morale, and you could tell stories about how you counter patriarchy in different ways and so on. But technical stuff, judgment writing, organizing your work, things of that kind. And it was Bridget Mabandla, the Judicial College now in Judicial Training College is named after her in South Africa, Minister of Justice. She asked for that program. These things don't just happen. They are fought for, and they're organized, and they're backed up. And Mandisa Maya already emerged at that stage as resolute and determined as anybody, as hardworking, and as collegial. So when you see that form of intervention producing results that are spectacular, they're beautiful, they're wonderful, it gives you courage to deal with other problems and difficulties. There's a very strange, it's very strange, you know, when you're blown up and you lose an arm, you discover how often the word arms, hands, and so on, thumbs, crops up in the English language. So I wanted to say, as somebody who doesn't have a safe pair of hands, that it's wonderful to feel our judiciary is guided by people with safe pairs of hands. And that's why, then I'll conclude with this, why I say that this is the country we were fighting for. And it's that country and the people who are functioning within the highest values of that country, who draw on the experience of our struggles and have the enlightenment and the impetus that comes from a challenging young generation to think fresh ideas and new approaches, that gives me confidence. I wish I could send a message to Mandy. I don't know well enough to call her Mandy. I'm so jealous of my colleagues who've been direct associates with us. Now I'm going to. So Mandy, we just saw your picture up there. It was lovely, lovely, lovely hearing you, your strong voice, the confidence, the clarity of the ideas, the emphasis on transformation, Ubuntu, the value system that underlines your work, and your emphasis on courage, the importance of courage. I wish you a very good recovery so that you can move around and get around. And I wish the Constitutional Court to carry on building on what our generation laid foundations for, and doing so with the elan and the spirit and the composure that I think we managed to accomplish. Thank you.
I was supposed to stop Albie after 10 minutes. Anybody had the gumption in the audience to do so, you're welcome to do so. In all seriousness, I think Albie has set the tone for the rest of the conference now. We understand where we come from and to understand what our duty is in this country to uphold constitutionalism. And so looking at the program, I know that we're going to engage fully in it. And Albie's was to do the vote of thanks, but I'd like to thank him for his vote of thanks. But also for what he has sacrificed for this country. And if you read his books, The Soft Vengeance of an Albino Terrorist and other books, and you look at Albie, 91-year-old, as active as ever. No wonder that George Clooney summoned him to Hollywood for the Albie Awards. Ladies and gentlemen, thank you for your attention, and thank you again for accommodating us under very challenging circumstances. It's ended with a highlight with a vote of thanks. And may I say that I share those sentiments about our Chief Justice. I can tell you now that she refuses to be called Chief Justice by us, and we all call her Mandy. So that is the Chief Justice that she is. I'm going to ask my colleague, Professor Ukore, just to come forward to tell us the logistics. Is you around? There you are. You, just to tell us the logistics about the function. Can I give you the mic? You can stand right there.
I can stand right here because I think everybody can hear me. We will conclude here. You can go out there, straight up the stairs. It's very close by, and we're going to have a cocktail reception.
And we are adjourned. Thank you.